Greetings, and welcome to Massage Therapists, Mandated Reporters. I am Kirby Clark Ellis, MMT, BCTMB. Content warning. This continuing education course is made with care and sensitivity. However, it does contain potentially distressing topics that may make participants uncomfortable or trigger a traumatic response. This course makes references to topics on bodily harm, child abuse, child sexual abuse, child neglect, alcohol and narcotic use, abortions, child pregnancy, genital mutilation, sexual exploitation, prostitution and pornography, grooming, restraints, abandonment, the marriage of minors, among others. This course is not designed to discuss specific or gratuitous situations and may only refer to these topics in line with Arkansas law. Participant discretion is advised. Take consideration of your own comfort and sensitivity before proceeding. Seek resources in your local community to support your own mental and emotional health. This is a look at our syllabus. So what is a mandated reporter? Mandated means that it is legally required. Mandated reporters are required by law to make a report to the Arkansas Child Abuse Hotline if there is reasonable cause to suspect a child has been subject to maltreatment, died as a result of maltreatment, or may die as a result of conditions or circumstances of maltreatment. Mandated reporters are designated by the Child Maltreatment Act, Silk Road Title 12, Chapter 18, Section 101 et sec. These are individuals that are often the first adults to witness the signs of child maltreatment. As of August 2023, massage therapists in Arkansas were added to the list of mandated reporters. The responsibility of protecting children rests on all of us, but mandated reporters have a unique role with clearly defined boundaries. Many professions, especially those that work close with children and underage populations, are designated as mandated reporters. Child care, foster care workers, coroners, daycare center workers, dentists, dental hygienists, domestic abuse advocates, domestic violence shelter employees or volunteers, DHS employees, foster parents, judges, law enforcement officials, licensed nurses, medical personnel, including administrators, mental health professionals or paraprofessionals, osteopaths, peace officers, physicians, prosecuting attorneys, residential interns, part or full-time employees of public or private schools, including counselors, officials, teachers, coaches, directors of athletic, non-athletic organizations, teams, clubs, and volunteers 21 years and up, social workers, surgeons, court-appointed special advocate staff or volunteers, juvenile intake probation officers, clergy members including ministers, priests, rabbis, accredited Christian Science practitioners and similar counterparts, employees of child advocacy and child safety centers, attorney ad litems, child abuse advocates including volunteers, rape crisis advocates including their volunteers, child abuse advocates including volunteers, victim or witness coordinators, victim assistant professionals including their volunteers, employees of CACD and Arkansas State Police, employees and volunteers of reproductive healthcare facilities, nonprofit organization employees, child welfare ombudsman, licensed massage therapists, and finally, any person 18 years or older that observes child maltreatment. It is important to know what our role as mandated reporters is and what it is not. Arkansas law requires us to call the Child Abuse Hotline if we have reasonable cause to suspect a child has been subjected to maltreatment, died of maltreatment, or is in a condition or circumstance that could reasonably result in death from maltreatment. It is our role to report our suspicions to the Child Abuse Hotline. It is not our role to investigate our suspicions. It is not our role to take custody of a child or remove them from their home. A person may immediately notify the Child Abuse Hotline if they, 1, have reasonable cause to suspect that child maltreatment has occurred, a child has died from child maltreatment, or 2, observe a child being subjected to conditions or circumstances that would reasonably result in child maltreatment. For more information, look at Silcro Title 12, Chapter 18, Section 401. You fulfill your legal obligation when you call the Child Abuse Hotline and report your suspicions. You are the eyes and ears that are designated to recognize the signs of child abuse and neglect. As a mandated reporter, if you make a report in good faith, you are immune to suit in civil and criminal liability. For more information, check out Silcro Title 12, Chapter 18, Sections 107 and Sections 401. Even if your report is determined through the investigation process to be unsubstantiated, you are still granted immunity to civil and criminal liability. In order to not receive immunity from liability, the law would have to prove you intentionally made a false report. Although it can be intimidating to call the hotline, remember that we play a crucial role in protecting children from maltreatment. Confidentiality and anonymity of those who make reports is the law. For more information, look at Silcro Title 12, Chapter 18, Section 104. Any data, records, or documents that are created, collected, or compiled by or on behalf of the departments shall not be subject to disclosure under the Freedom of Information Act of 1967. There are lengthy clauses. For more information, they start at Silcro Title 12, Chapter 18, Section 709, in the law about specific circumstances about who and how releases of information is made to law enforcement, prosecuting attorneys, and courts, specifically protecting the identity of those who make the reports. Investigators cannot disclose the identity or name of the reporter without an order from a judge. And again, the court would have to have reason to believe that a false report was made for that to happen. A mandated reporter commits the offense of failure to notify in the first degree if they, 1, have reasonable cause to suspect that a child has been subjected to or died from or reasonably could die from child maltreatment, and 2, knowingly fail to notify the child abuse hotline. Failure to notify by a mandated reporter in the first degree is a Class A misdemeanor. A mandated reporter commits the offense of failure to notify in the second degree if they, 1, have reasonable cause to suspect that a child has been subjected to or died from or reasonably could die from child maltreatment, and 2, recklessly fails to notify the child abuse hotline. Failure to notify by a mandated reporter in the second degree is a Class C misdemeanor. You may also face suit in civil court and revocation of licenses. False reports are not failure to notify or unsubstantiated reports. A person commits the offense of making a false report if they, 1, purposefully make a report containing false allegations to the child abuse hotline, knowing the allegation to be false. A first offense of false report is a Class A misdemeanor. A subsequent offense of false report is a Class D felony. If it is found by a court of competent jurisdiction that the reporter knowingly made a false report, the court may order release of identifying information regarding the reporter, and immunity from civil and criminal liability will not be granted. The purpose of the Child Maltreatment Act is to provide a system for the reporting of known or suspected child maltreatment, ensure the immediate screening, safety assessment, and prompt investigation of reports made, ensure immediate steps are taken to protect a maltreated child and other children under the same care and at risk of maltreatment, and place a child whose health or well-being is in immediate danger in a safe environment, provide immunity from criminal prosecution for individuals that make good faith reports, preserve the confidentiality of all records to protect the rights of the child and the rights of the child's parents or guardians, encourage cooperation of state law enforcement, courts, state agencies during the investigation, assessment, prosecution, and treatment of child maltreatment, and stabilize the home environment if a child's health and safety are not at risk. There are 12 subchapters or sections of this law. Subchapter 1 are general provisions. Subchapter 2 deal with offenses and penalties. Subchapter 3 is the child abuse hotline. Subchapter 4 is for reporting suspected child maltreatment. Chapter 5 handles notice procedures after a report of suspected child maltreatment has been made. Subchapter 6 is the investigative proceedings. Subchapter 7 is the investigative findings. Subchapter 8 deals with administrative hearings. Subchapter 9 is the Child Maltreatment Central Registry. Subchapter 10 is protective custody. Subchapter 11 deals with public disclosure of information on fatalities and near fatalities. And finally, Subchapter 12 is training regarding sexually exploited children. The Child Maltreatment Act is Arkansas Code Annotated, or ACA, Silcro, Title 12, Chapter 18, Section 101 et seq. AR Code, or ACA, means that it is the law in Arkansas. That symbol is a section mark, or a Silcro. This law starts with the numbers 12, 18, 101. 12 being the title, 18 being the chapter, and 101 being the section. In Arkansas law, 12 is the Law Enforcement, Emergency Management, and Military Affairs title, and 18 is the Child Maltreatment Act chapter. Under sections 101 et seq, the law can also look like this: subsection, subdivision, paragraph, subparagraph, and sub-subparagraph. The legal term et seq is used throughout this law. It is Latin for "and the following." It denotes a list or series of continuing items. Abandonment is the failure to maintain support and regular contact without just cause, with intention to permit the condition to continue for an indefinite period. Abortion is the act of using or prescribing any instrument, medicine, drug, substance, device, or means to terminate the clinically diagnosable pregnancy, except in specific circumstances. Caretaker means a parent, guardian, custodian, foster parent, or any person 14 years of age or older entrusted with a child's care, including an agent or employee of a public or private residential home, child care facility, public or private school, excluding the spouse of a minor. Central Intake, also known as the Child Abuse Hotline, is the unit established by the Department of Human Services for purposes of receiving and recording notifications pursuant to the Child Maltreatment Act. Child or juvenile is an individual from the ages of birth to 18 years of age. Department means the Department of Human Services and the Division of Arkansas State Police. Deviant sexual activity are acts of sexual gratification involving penetration of the mouth, anus, or vagina of one person by the penis, body member, or foreign instrument of another. Forcible compulsion means physical force, intimidation, threat, whether expressed or implied, of physical injury, death, rape, sexual abuse, kidnapping. If an act is done against a child's will, also with thoughts to age, developmental state, and stature of the victim in relationship to the victim of the assailant, and deprivation of affection, rights, and privileges. Guardian is any person, agency, or institution whom a court of competent jurisdiction has so appointed. Indecent exposure is exposure of the person's sexual organs for the purpose of arousing or gratifying the sexual desire of any person where the conduct is likely to cause affront or alarm. Near fatality is an act, as certified by a physician, placing a child in serious or critical condition. Parent means the biological mother, adoptive parent, or a man married to a mother at the time of conception or birth of the child. Pornography includes pictures, movies, videos that lack serious literacy, artistic, political, or scientific value, and when taken as a whole and applied to contemporary community standards, appeals to the prurient interest. It includes material that depicts sexual conduct in a patently offensive manner or obscene or licentious material. Reproductive healthcare facility is any office, clinic, or other physical location providing abortions, abortion counseling, abortion referrals, contraceptives, contraceptive counseling, sex education, or gynecological care and services. Serious bodily injury means bodily injuries that involve a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of a bodily member, organ, or mental faculty. Severe maltreatment includes sexual abuse, sexual exploitation, acts or omissions that may or do result in death. This also includes abuse that involves the use of a deadly weapon, bone fractures, internal injuries, burns, immersions, suffocation, abandonment, the medical diagnosis of failure to thrive, or causing substantial or observable changes in the behavior or demeanor of the victim child. Sexual contact is acts of sexual gratification that includes the touching, directly or through clothing, of the sex organs, buttocks, or anus of a person or the breasts of a female. This does not include normal affectionate hugging. Significant other means a person with whom the parent shares a household or who has a relationship with the parent that results in acting in loco parentis, regardless of the living arrangements. Subject of the report means the offender, the custodial or non-custodial parents, guardians, and legal custodians of the child subjected to suspected maltreatment, and the child who is the subject of suspected maltreatment. Underaged juvenile offender is any child younger than 14 years of age for whom a report of sexual abuse has been determined to be true for sexual abuse to another child. Voyeurism means looking into a private location or place where a child may reasonably be expected to be nude or partially nude with the purpose of sexual gratification or arousal. Died suddenly and unexpectedly means a child's death was not caused or by a known disease or illness which the child was under a physician's care at the time of death. This includes sudden infant death syndrome, accidents, suicides, homicides, or other undetermined circumstances. Female genital mutilation is any procedure that involves the partial or total removal of external female genitalia or any procedure that is harmful to the female genitalia, with specific exemptions. Family member is a person within the 5th degree of consanguinity by virtue of blood or adoption. Fictive kin is a person who is not related to a child by blood or marriage and has a strong or positive emotional tie in the life of the child or life of the parent if the child is an infant. Imminent harm are acts of harm that is a danger to the physical, mental, or emotional health of a child that is constrained by time and may only be prevented by immediate intervention by a court. Grooming means to knowingly disseminate to a child 13 years of age or younger material that depicts sexually explicit content with the purpose to entice, induce, or groom the child to engage in sexual intercourse, sexually explicit conduct, or deviant sexual activity, unless the actor of the alleged grooming is not more than 3 years older than the victim. Disseminate means to allow to view, to expose, to furnish, to present, to sell, or to otherwise distribute, either electronically, virtually, or in the physical presence of a child. Ultimately, there are some cases where you just won't know for certain that child maltreatment is taking place. There are 3 main categories of how you would know if it is appropriate to make a report. They include you observing child abuse or neglect happening in person. A child discloses an incident of abuse or neglect to you, and you have reasonable cause to suspect that abuse or neglect of a child is happening. Disclosure may be difficult for the child. Always keep their perspective in mind. They may have been threatened not to tell. They may feel embarrassed or ashamed about what happened. They may have already tested the waters with other adults and decided it was unsafe to disclose. They will be watching and analyzing your reaction. They will likely be anxious about telling you and what will happen next. As often as possible, keep the child informed about what will happen next and be honest with them. Body language. Come down to the child's level when they speak to you. Maintain the same eye level with them and respect their personal space. Don't lean in too close while they are talking. Facial expressions. Be mindful of how your face expresses your emotions. You may feel shocked, angry, or even horrified by what the child tells you, but keep a calm facial expression. Never lead the child. Let the child tell the story of their experience. Don't ask leading questions or insert your own narrative or make assumptions. Don't put words in the child's mouth or ideas in their head. Limit your questioning. The child will be interviewed about the same abuse or neglect experience by investigators, possibly including child enforcement as well. The risk of re-traumatization should be avoided at all cost. Improperly conducted interviews could negatively impact the subsequent investigation. Leave the interviewing to the trained professionals. Remember, all that you need is reasonable cause to suspect maltreatment in order to make a report. When a child discloses abuse or neglect, it is important to take extra care in how you respond. Choose your words carefully. Try to use age-appropriate words that they can easily understand. You should never promise a child that you will keep what they disclose to you as a secret. Explain to them your role is to ensure their safety. Assure them that you will not share this information with any of their peers or anyone that doesn't really need to know. Reassure the child that you still care about them and that what they have shared with you doesn't change how you feel about them. Assure them that you believe them. They may fear that you will think that they are a bad person or that what happened was their fault. Let the child know that they have a right to safety and that you will help them retain that right. And be honest. The child will likely have a lot of questions about what will happen that you probably cannot answer. Don't make up an answer for them, and don't set expectations that might not come true. It is okay to tell a child that you don't know what will happen next. Sometimes, after a child has made a disclosure to an adult, they will later say that nothing happened. This does not mean that they weren't initially telling the truth at the time when they made their disclosure. Recanting can be a natural reaction from a child based off a number of factors. What are some reasons you think a child would recant their story? Fear, parental pressure, and threats from the alleged offender could all be factors. There are 3 categories of child maltreatment specified in the law. These are child abuse, child sexual abuse, and neglect. There are 2 forms of child abuse: physical abuse, which occurs when a person responsible for the child's welfare inflicts physical injury that is non-accidental or creates substantial risk of physical harm. This also includes deliberately inflicting cruel or unusual treatment that results in physical or mental suffering. It includes excessive corporal punishments or overly harsh discipline, regardless of the intention. This also includes giving or allowing a child to have a controlled substance or exposing a child to the manufacturing of methamphetamine is also considered physical abuse. And emotional abuse, which may cause children to have trouble functioning at normal performance levels. This includes similar impairments of the intellectual and psychological development. However, emotional abuse may only be reported by medical or mental health professionals, teachers, school counselors, or daycare workers. For more information, look at Silkro Title 12, Chapter 18, Section 308. Physical abuse can include bruises, bites, bone fractures, cuts, welts, and burns. Permanent or temporary disfigurement, impairment of bodily organs, and interfering with a child's breathing are also included as physical abuse. The following intentional or knowing acts without justifiable cause are also forms of physical abuse of a child: throwing, kicking, burning, biting, cutting, striking with a closed fist, shaking, striking on the face or head, pinching, biting, or striking the genital area, tying the child to a fixed or heavy object, or binding or tying a child's limbs together, giving or permitting the child to consume or inhale poisonous or noxious substances, giving or permitting the child to consume or inhale non-prescription mood-altering substances, including marijuana, alcohol, narcotics, and over-the-counter drugs if overdosed, and chemicals generated during the manufacture of methamphetamine. Munchausen syndrome, factitious illness by proxy, recruiting or harboring or transporting or obtaining a child for labor or services through force or fraud or coercion for the purpose of subjection to involuntary servitude or peonage or debt bondage or slavery. Obvious or outward signs can include unexplained marks on the body, including cuts, bruises, welts, burns, black eyes, fractures and dislocations, bruises or welts in various states of healing, clusters or patterns of marks or marks in the shape of objects, pattern burns, including cigarette or iron burns, and burns that are in the shape of objects, scald burns in immersion patterns, or hidden marks from typically exposed regions of skin. More subtle indicators might include behavioral changes, such as extreme vigilance and watchfulness, overcompliance, avoiding physical touch or contact, bullying smaller children, poor social interactions, fear of their parents or caregivers, including not wanting to go home, missing school, counseling, or other appointments for a prolonged period of time, and even harming animals. But please note, not every child displays overt changes. Sexual abuse of a child occurs when a person responsible for a child's welfare commits sexual penetration, which is any contact between the sex organ of one person and the sex organ, mouth, or anus of another person. This includes vaginal, anal, or oral sex. Penetration also extends to include contact between a foreign instrument manipulated by another person and the sex organ, mouth, or anus of another person. Sexual molestation is when the alleged offender touches the child or asks the child to touch them for sexual gratification or arousal of the offender or the victim. This includes fondling the child or having the child fondle the offender. And sexual exploitation, which is the sexual use of a child for sexual arousal, gratification, advantage, or profit. This includes child pornography, forcing a child to watch sex acts, or exposing genitals to a child. Sexual abuse does not always involve a child being touched inappropriately by an alleged offender. Exploitation can include the child being allowed or encouraged to participate in prostitution, obscene photography, or filming or obscenely depicting, posing, or posturing the child. As defined in the Child Maltreatment Act, sexually exploited child means a person less than 18 years of age who has been subjected to sexual exploitation because the person is a victim of trafficking of persons, is a victim of child sex trafficking as it existed on January 1st, 2023, or engages in an act of prostitution or sexual solicitation. Sexual abuse can include sexual intercourse, deviant sexual activity, or sexual contact by forcible compulsion, or the attempted or solicitation of those acts. The following acts are also forms of sexual abuse of a child: indecent exposure, forcing the watching of pornography or live sexual activity, forcing the listening to a phone sex line, acts of voyeurism, recruiting or harboring or transporting or obtaining or patronizing or soliciting for the purpose of commercial sex acts, and grooming. The majority of victims of child sexual abuse are abused by someone the victim knows and trusts. Obvious or outward signs can include sexual knowledge beyond what is age appropriate, discharge or reoccurring pain or itching in genital or anal areas, sexually transmitted infections or diseases, frequent bladder or urinary tract infections, genital injury, unexplained regression or fear, marks with varying histories or causes, or torn or bloody underclothes. Other indicators include behavioral changes that could include nightmares, regressive behaviors like bedwetting, a child forcing others to do things that are sexual in nature, for example, telling persons to take off their clothes, or trying to forcibly undress others, or aggressively trying to touch the genitals of adults or other children, and getting angry when they are prohibited from doing so. Sexual acts children do to themselves, which can include exposing their genitals in public and getting angry when they are prohibited from doing so, and touching or rubbing their own genitals to the point of hurting themselves. The developmental age of the child and power differential is also important to assess in the signs of sexual abuse. It may be perfectly normal for two children of the same age, same developmental level, and same power position to be involved in sexual exploration. It becomes a point of concern and should raise suspicion of child abuse when a child uses force, bribery, or threats, or displays sexual knowledge beyond what is age appropriate. A child that is developmentally delayed or functioning at a level younger than their physical age is engaged with sexual behavior with other children without developmental delays, and a child that is physically larger or stronger than the other child. Not all children display overt behavioral changes. Sexual predators will often abuse children in manners that do not leave physical signs. These manners can include fondling the child, exposing themselves to the child, having the child perform sexual acts on the alleged offender, other adults, or other children. Even sexual penetration does not always leave obvious physical signs of abuse. Neglect occurs when a parent or responsible caretaker fails to provide the minimum requirements for their child. This can be through acts of omission, which includes adequate supervision, medical care, medical attention and medical treatment, food, clothing, shelter. Neglect can also include significant delays to the provisions of these necessities. Other forms of neglect include the birthing parent taking illegal drugs during their pregnancy, placing a child at risk of harm or dangerous situations, exposing a child to hazardous living conditions, a child being present during the manufacture of methamphetamine, abandonment, failure or refusal to prevent abuse of a child, lack of follow-through on prescribed medical treatment plans that could result in long-term harm, failure to ensure the child between the ages of 6 and 17 is enrolled in school or being legally homeschooled, and acts or omissions that cause the child to be habitually absent without justification from their school. More children suffer from neglect in the United States than any other form of child maltreatment, and it results in more deaths than the other forms of child maltreatment. Poverty is often mistaken for neglect. This leads to an increased number of invalid reports. Poverty does not necessarily equate to neglect. Most parents can provide the minimum requirements that are listed above for their child. Neglect perhaps has the most obvious and overt signs of all forms of child maltreatment. Possible signs of child neglect include the child being hungry in the morning or at the start of the day, poor hygiene of the child, evidence of no or poor supervision, a condition of being underweight, poor growth, failure to thrive, the child being inappropriately dressed for the weather, and erratic attendance at school. A single incident regarding indicators for neglect does not necessarily meet the legal definition of neglect. It is just as important to also clearly understand what is not abuse or neglect. Sometimes a report is made because of a concern that could be a violation of a court order or requires law enforcement, but they aren't legally recognized as child maltreatment and cannot be accepted as a report for investigation, such as a child not being picked up from school or daycare, a child missing court-ordered visitations, a child not being placed in the appropriate car seat, a child riding in a car with an adult who is smoking, spanking or other corporal punishment that is reasonable or moderate and is used to restrain or correct the child. A child suffers transient pain or minor temporary marks. A dirty home that is not hazardous. An older child left home alone and is capable of caring for themselves. And a child left in the care of an adult relative who has often cared for the child previously, even if the parent failed to make arrangements for childcare, or an infant 30 days old or younger being dropped off at a designated safe haven. For more information, look at Silk Road Title 9, Chapter 34, Section 202. All children are at risk for potential maltreatment. However, some groups tend to be more vulnerable to child abuse. Preschool children are vulnerable to abuse and neglect because they might not be able to talk yet. Even if they can talk, they may not know the words to use to describe what has happened to them. These children are dependent on adults for all of their needs and aren't necessarily seen by more adults than their caregivers. Abusers can target preschoolers because they may be unable to tell or understand what is happening to them. Physical signs and behavioral changes may be the only indicators that nonverbal preschoolers are being abused. Many people find it hard to believe preschool children are abused, but it does happen. There is a common misconception that preschool children are inherently unreliable sources of information. Child predators know this myth, and they exploit it to their advantage. Research has shown that, when questioned properly, even very young children are reliable sources of information. All children are at risk for potential maltreatment. However, some groups tend to be more vulnerable to child abuse. Children with disabilities, including those with speech or language impairments, emotional or learning disabilities, and physical health impairments. These children are at higher risk of maltreatment for several reasons. Family stress. Without access to resources and support to help care for their child, this leads to extreme stress on caregivers and put the child at high risk for abuse. Stress does not justify or excuse abuse, but it is a risk factor. Isolation. Children with disabilities can lead lives of significant isolation from others. This isolation can provide abusers with more opportunities to prey on the child without discovery. Dependency. Children with disabilities may be even more dependent on their caregivers due to their disability and inaccessibility to care for themselves in ways other children may develop. This dependency can also lead to reluctancy to disclose their maltreatment because they fear no one else will take care of them. Limited privacy can also contribute to a lack of opportunity to disclose. And difficulty communicating. This can be more common in blind, deaf, or those with speech and language disabilities. This is obviously a higher risk factor if the child is unable to describe or explain what happened to them to others. Abusers know this and can specifically target this population of children because they believe they will not be able to tell their story. Similarly to preschoolers, there is a popular belief that children with certain disabilities are not credible sources of accurate information. Even if a child cannot talk or has difficulty expressing themselves, this should not prevent you from making a report if you suspect child maltreatment. Trained professionals have several techniques they can use to investigate, interview, and communicate with nonverbal children. All children are at risk for potential maltreatment. However, some groups tend to be more vulnerable to child abuse. LGBTQIA children, meaning lesbian, gay, bisexual, transgender, queer, questioning, intersex, and asexual children, often have fewer social supports and opportunities to discuss their sexual and gender identities and sexual exploration with their peers, parents, or other adults, when in contrast to their cisgender and heterosexual peers. LGBTQIA children often fear ridicule or rejection from those closest to them. This population is at higher risk of isolation from their peers, discrimination from adults, and punishment from their parentals. Predators may target this group of children or adolescents based on the chance that they have no support from the adults in their lives. All youths may be ashamed to tell others that they were sexually assaulted by someone of the same gender. but especially LGBTQIA children if they are questioning their identity or were punished, ridiculed, or rejected when disclosing their sexual or gender identities. Although some sexual assault victims are LGBTQIA, some people have a mistaken belief that boys who were sexually abused by men will always become homosexual or otherwise queer. This generality is simply not true. This faulty belief system only makes it harder for children to disclose their sexual abuse histories. The Child Abuse Hotline is a unit established within the Department of Human Services, DHS, and the Division of Arkansas State Police, ASP, or other designee with the purpose of receiving and recording notifications and reports of child maltreatment. The Child Abuse Hotline shall, meaning must, be staffed 24 hours a day and have statewide accessibility through a toll-free telephone number. All persons, whether they are mandated reporters or not, may use the Child Abuse Hotline to report child maltreatment or suspected child maltreatment. The toll-free telephone number is 1-800-482-5964 or 844-SAVE-A-CHILD. Facsimile transmissions or fax is available using 1-501-618-8952. Reports can also be submitted online at mandatedreporter.arkansas.gov. There is no need to call, fax, and submit a report online. Choose one of these only. If there is a reason to suspect the life of a child is in immediate danger, contact the nearest local law enforcement agency or dial 911 and then follow up with a call to the hotline. Call the hotline to make a report. You should organize the information beforehand if appropriate. A hotline worker will accept your call. If a worker is not available, the following recording will be heard while on hold. Please hold. All calls are answered in the order they are received. Report information on what you have seen and heard. You will be told whether the report will be accepted. If the report is not accepted and you disagree with that decision, you may ask to speak with the hotline supervisor. You may request references to appropriate resources. Fax reports may only be made by mandated reporters providing their contact information and used only in non-emergency situations. Online reporting may be used in non-emergency situations by an identified mandated reporter that provides contact information, including their name, phone number, and email address. The hotline will provide confirmation of the receipt of a report made online. You will have to create a profile to make a report online through the Arkansas Mandated Reporter portal. If the report is a criminal matter and the information does not meet child maltreatment criteria, the hotline will forward the report to law enforcement. The hotline accepts over 35,000 reports for investigation each year. In the United States, there are 3 million cases reported and 700,000 end up being confirmed. What must be included in a report? The hotline will accept a report if the alleged victim is or was 18 years of age or younger at the time of the act or omission of child maltreatment. The allegation, if found to be true, would constitute child maltreatment as already defined. The report is of the death of a child who has died suddenly and unexpectedly. Sufficient information is provided to identify and locate the child or the child's family. The child or child's family are present in the state of Arkansas, or the incident occurred in the state of Arkansas. Reporter information. You must provide you and or your agency's contact details. Alleged victim's age, address, school or daycare, and etc. information. Siblings of the victims, including their age, address, school and daycare, and etc. information. The parents or caregivers. Details on the victims, guardians or caregivers. Alleged offenders. Details about the alleged offender of the abuse. A narrative summary. You need to include what happened, who did what to whom, when and where the incident occurred, and the injuries sustained. Be as detailed as possible. The Child Abuse Hotline shall not accept an anonymous report. Many people ask why the Department of Human Services and the Arkansas State Police cannot accept an anonymous report. There are several reasons for not being able to accept anonymous reports. The investigator will be unable to contact you, verify your information, or obtain more details. The investigation will be weakened if the investigator cannot contact you. Because you would be unreachable, you could not be notified of the results of the investigation. And finally, perhaps most important, should something happen to the child after you make your report, you would have no legal proof that you fulfilled your obligation as a mandated reporter. You should allow approximately 30 minutes to complete a report. Any report not completed and submitted within 8 hours will be deleted. The report will not be saved, and no information will be forwarded to the Arkansas State Police. Only one family can be included in each report. The hotline cannot assist with case updates or custody issues. You must also acknowledge that the child victim is not in immediate danger. You should keep record of the date and time and who you spoke to. Remember, reports of intellectual, emotional, or psychological abuse can only be made by medical professionals, mental health professionals, or paraprofessionals, teachers, school counselors, daycare workers. Similarly, reports alleging Munchausen syndrome or by proxy or fictitious illness can only be accepted if the reporter is a medical professional. For more information, look at Silk Road Title 12, Chapter 18, Section 307. So you've made a report and fulfilled your legal obligation as a mandated reporter. Now what? The next steps aren't in our power or control as mandated reporters, but it can be helpful to know the general regular progression of what will happen next. Notices, investigations, findings, administrative hearings, child maltreatment central registry, and protective custody. Notices are confidential and may only be disclosed in accordance with the law, but in general, the DHS and ASP will notify the following of any report within 5 business days: the legal parents or guardians or foster parents of the victim and or alleged offender, a mandated reporter if they made the initial report and it has been accepted. DHS and ASP will immediately notify law enforcement in the event of severe maltreatment. If the department takes a 72-hour hold on a child, or if a court awards custody to the department, DHS will notify the child's school. There are also special protocols of who to notify involving residential facilities and United States military organizations. If the alleged offender works with any of the 4 vulnerable populations, which we'll get to in a later slide, notices are sent to an alleged offender's employer, superintendent, principal, or equivalent position, those in charge of the paid or volunteer activity, the appropriate licensing or registering authority, or the school the alleged offender is enrolled in. The vulnerable populations include children, the elderly, individuals with disabilities, and individuals with mental illness. The Department of Human Services shall determine the risk level of maltreatment involved between alleged offenders and these vulnerable populations. Investigations of child maltreatment reports may be conducted by DHS or ASP. All investigations shall begin within 72 hours or 24 hours in cases of severe maltreatment, neglect, and sudden and unexpected death. Upon request, law enforcement may accompany the person that conducts the interview. DHS may make referrals or provide services during the investigation. Investigations shall include interviews with the alleged child victim, parents, including custodial and non-custodial, the alleged offender, if it's not either of the parents, current and or past healthcare professionals, if they made the report, and any other related persons. Investigators will have discretion in limiting the person present during an interview with an alleged child victim. Investigators shall have the right to enter into or upon a home, school, or any other place for purposes of conducting the interviews and investigation. Investigators shall be allowed access and the right to inspect public and private school records and personnel records of employees or volunteers, as well as obtaining a criminal background check. Each investigation shall have made an investigative determination within 45 days. However, an additional 15-day extension can be permitted. If the report is determined to be valid, the local police department and prosecutor's office will be notified of the alleged crime. A police investigator may contact you in addition to ASP or DHS. If the report is determined to not be valid for child abuse or neglect, the investigator will determine if any safety concerns for the child exist. A complete written report shall be made at the conclusion of the investigation, which shall include the names and addresses of the child and their legal guardians or caretakers, the age, sex, and race of the child, the nature and extent of a child's present and past injuries, the investigative determination, the nature and extent of child maltreatment, the name and address of the person responsible for the injuries of child maltreatment, the services offered and accepted, the family composition, the source of the notification, and the person making the notification, their occupation, and where to contact them. There are 4 categories of determinations of investigations. They are unsubstantiated, which is the determination that shall be entered when the allegation of the report or investigation is not supported by a preponderance of the evidence. True, which is the determination that shall be entered when the allegation of the report or investigation is supported by a preponderance of the evidence. True but exempted is the determination of true, but the alleged offender's name shall not be placed in the Child Maltreatment Central Registry based on religious belief exemptions and juvenile offenders. Inactive is the determination entered when the investigation cannot be completed because DHS or ASP are unable to locate or identify the alleged offender or alleged victim, and any other determination cannot be established without interviewing those persons. DHS and ASP shall notify the alleged offender whether the determination is true or unsubstantiated. The notice shall include a statement that requests for an administrative hearing shall be made within 30 days of receipt. In other cases, the alleged offender's legal parents or caretakers and or their legal counsel, as a mandated reporter who submits a report, you will receive a letter informing you of the finding in the case you made. Other specific information about the report cannot be released to you. Determinations and findings of an investigation are intended by law to be kept confidential and shall only be disclosed in specific procedures to specific entities as prescribed by the Child Maltreatment Act. You may be contacted by investigators for additional information during the investigative process. Following a report that is determined to be substantiated and true, you may be asked to share new information about a child's safety and welfare within the caseworker, or you may be asked to make a new report if new abuse or neglect incidents are taking place. Administrative hearings shall begin within 180 days from the date of receipt of a request for the hearing. However, delays attributed to either party shall not count against this time frame if there exists good cause. An administrative law judge may conduct an administrative hearing by video teleconference in lieu of an in-person hearing if neither party requests in-person hearings. Administrative law judges may grant stays and continuances under specific circumstances. They may also amend the investigative determination to conform with the evidence presented in the administrative hearing. Administrative hearing decisions and hearing records, including all exhibits, shall remain confidential and may only be used or disclosed in very specific circumstances prescribed by the law. In an administrative hearing, an administrative law judge shall determine whether a preponderance of the evidence supports a finding that an allegation of child maltreatment is true, and whether DHS abused its discretion in determining that an offender may pose a risk of maltreatment to a vulnerable population. An administrative law judge shall direct the name of an offender to be placed on the Child Maltreatment Central Registry if a preponderance of the evidence supports a finding that an allegation of child maltreatment is true and DHS did not abuse its discretion in determining that the offender may pose a risk of maltreatment to a vulnerable population. Due process has been satisfied when the alleged offender, 18 years of age or older, was provided written notice of the true investigative determination, but failed to request an administrative hearing. The alleged offender, 18 years of age or older, timely requested an administrative hearing, and a decision has been issued by the administrative law judge. The alleged offender was a child at the time of the act or omission of child maltreatment, and the child or their legal parents or guardians waived the administrative hearing, or the administrative law judge issued a decision. Upon satisfaction of due process, if the investigative determination is true, the alleged offender's name shall be placed on the Child Maltreatment Registry, which is a statewide registry established within DHS and shall contain records of cases on all true investigative determinations of child maltreatment. Unsubstantiated determinations shall not be included in the registry. If an alleged offender's name is provisionally placed in the registry, any disclosure of the registry shall include a notation that the name has only been provisionally placed in the registry. An offender's name shall remain in the registry unless the name is removed pursuant to the Child Maltreatment Act or another statute, the name is removed under a rule, the name was provisionally placed in the registry, and the alleged offender subsequently prevails at an administrative hearing, or the offender prevails upon appeal. True reports of child maltreatment are confidential and may only be disclosed in specific circumstances to specific entities as prescribed by the law. A police officer, law enforcement, a juvenile division of circuit court judge, or a designated employee of the Department of Human Services may take a child into custody, or any person in charge of a hospital or similar institution, or any physician treating children may keep that child in their custody without the consent of their parents or guardians, regardless of the need of additional medical treatment. This happens only under specific circumstances as prescribed by law. The child is subjected to neglect, and there is determined a substantial risk of serious harm, such that the child or children need to be removed. Circumstances or conditions are such that if they remained in the residence or care and custody of their parent or caretakers, it would present immediate danger to the child's health or physical well-being. However, custody shall not exceed 72 hours, excluding weekends and holidays. If the department assesses the health and safety of a child or children and determines that the child cannot stay in the care or custody of their parent or caregivers without the implementation of an immediate safety plan, then the department may implement such a plan, which includes services to address the child's safety. Reassessment of the child's safety may take place within 30 days of implementation of the immediate safety plan. In some specific cases, a county sheriff or chief of police may place a child that is in their custody in a DHS foster home. The child's health and safety is of paramount concern in determining whether or not to exercise custody. No one, including the family, DHS, ASP, or local law enforcement, shall allow a child to be placed in a non-approved or non-licensed foster home, shelter, or facility. If I call the hotline, are you sure that the child's family won't be told by name? Confidentiality and anonymity of reports, including the name of the reporters, is the law. Investigators cannot disclose the name of the reporter without an order from a judge, and a judge must have reason to believe that a false report has been made. What happens if the family can tell I made the report? Is there any protection for me from the family? Parents and/or alleged offenders are legally entitled to a list of those interviewed during an investigation, but there is no notation of who made the initial report. You are not required to disclose or confirm if you have been interviewed or discuss your interview with the family. What happens if a report I made is determined unsubstantiated? The law will presume that you made the report in good faith. If I know other professionals work with the family, do I still need to make a report? As a mandated reporter, you should never make the assumption that someone else, even other mandated reporters or professionals, that is involved with the child, have already made a report. It is your responsibility to call and report what you know or suspect. Even if a report has already been made, your information is valuable to investigators and may help substantiate the report. Have I fulfilled my obligation when I tell my supervisor, colleague, or coworkers about my suspicion of child maltreatment? No. It is your responsibility as a mandated reporter to ensure a child maltreatment report is made to the hotline. Telling anyone else besides the hotline does not fulfill your legal obligation. You may want to suggest that you and a supervisor make the report together if you both have firsthand information about the child or situation. Does my employer, boss, manager, or supervisor have the authority to decide if I make a report to the hotline? No. There are very specific clauses in the Child Maltreatment Act that prohibit a school, agency, or employer from keeping you from making a report. They also are prohibited from making you notify or ask permission from anyone before making a report. What happens if I have reason to believe that abuse or neglect is going on, but I don't call the hotline and make a report? Mandated reporters who fail to notify the hotline may be charged with a misdemeanor in criminal court, which can result in fines, imprisonment, or both, or sued in civil cases. Mandated reporters with a license, like massage therapists, may be subject to the penalty of having their license revoked. Shouldn't I be allowed to be present with the child during an investigator's interview of that child? Not usually. The investigator will typically ask to conduct the interview with the child alone and away from any potential influence. Investigators do have discretion on who is present during an interview. However, if you are present at the interview, you may be called to testify when the case goes to court. Does a child always get removed from a home or custody of their guardians and caretakers? It depends. Investigators can only remove children from their homes when the child is in immediate danger of serious harm. Families are typically kept together whenever possible. This may require the implementation of an immediate safety plan. Investigators go to the home of the child, interview the families, and assess the safety of the child and other children in the same household should they stay in the environment. Where do children go when they have to be removed from the home? If the child is dependent and the report does not involve the caretaker, the parents or guardians may place the child in the care of an appropriate relative or friend. If there is no friend or relative that is willing or able to care for the child, or if the child is dependent neglected, the child will be placed in foster care. No matter where the child is placed, this is only temporary until a judge hears the case. When a child is taken into temporary protective custody, also known as taking a hold, DHS must notify a judge within 72 hours. The judge will decide if will remain in custody of DHS until probable cause hearing, which must take place within 5 days. It can be held, or if the child must be returned to the custody of their parents.